family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernard Owusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernard Owusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Hello, everyone. Wherever you are watching us all around the world, it's good morning, good afternoon, good evening, wherever you're watching us. I'm super excited to come your way today. As usual, it's our immigration education program today. BWF, is a very credible immigration company. They deal in immigration, civil litigation, family law, divorce, and many more. And they've won so many awards, in the UK. They also have a branch in Ghana. Today, I have one of the partners and also a solicitor from BWF Solicitors, in the name of Lawyer Eunice. I am your host, Vicky Newton. Today's topic is how can one apply for their immigration status in the UK based on their private life. Lawyer Eunice is going to take us through the eligibility criteria, what documents you might need to be eligible for this application. You can call us live on this program on 0744 8619 711. The number again is 0744 8619 711, or also send me a message on WhatsApp. Of course, we are live on Facebook, YouTube, and also on BWF radio as well. So whichever way is okay for you, we still need to hear from you. With all your contributions and comments, will make this program more interesting. I don't want it to be like a two-way kind of thing. Lawyer Eunice, explaining things to us, answering questions I put to her, just the two of us, but I want us to do it collectively. So please, please, please get all your friends, your colleagues, your loved ones. Definitely someone might need, help in this area. So share on all your social media platforms, inviting all your friends, colleagues, and loved ones to join in this discussion. So as I said, you can call me live in the studio on 0744 8619711, 0744 You can also send me a WhatsApp message, and I'll be very happy to send, pass on the message to Lawyer Eunice. Once again, you are welcome to hanging out with BWF solicitors. Let me quickly say hi to our lovely lady, ever faithful, ever committed, always taking time off her busy schedules to come our way to, answer questions, explain things to us, and also guide us on how we can regularize our stay in this country. Welcome, Lawyer Eunice.
Thank you so much, Vicky. How are you?
I'm good. I'm so excited to,
Yes,
away.
and I can see that you're looking all yellow and bright. This
Of
week has been a
course,
good
of
week, hasn't
course,
it?
of course, of course, of course. How has your week been? Even though I know
Ah,
you're busy, but I still have to ask you.
I know. Actually, today is Oliver's birthday. Oliver is 3
Oh,
today.
wow.
Yes, so um today I decided, do you know what? Let Oliver and his sister go out and enjoy a bit of the sunshine and the fun in the park. So he's gone out with his daddy. So Oliver is a big 3 today. So
Oh,
he
wow. Happy birthday, Eva.
I
Oh,
know I took him out and then he picked out his own card. I said to him, Oliver, I'm gonna get something. And then he went behind me and he was like, Mommy, I want Thomas, this book, this book. He didn't know it was a card. And then I looked at it and it said 3. I said, Oh my
oh,
goodness, this boy
wow.
knows what he wants.
That's it. For those of you who don't know who Oliver is Lawyer Eunice's son. Sometimes when we are having the program, he just feels like coming in to give mom the support. So we've seen him on our platform a few occasions, and today he's 3. So happy birthday, Oliver. Before I ask Eunice to first start with update, because definitely I believe that you guys are very keen to know what is happening, in regards to immigration. But before Lawyer Eunice goes, delves into the updates for the week, may I also inform all of you that this program is for just education purposes, because I believe that even though the topic we are discussing might be something of benefit to you, I believe that whatever is discussed here is not the final authority. You will have to contact Lawyer Eunice, and she will be able to help you out in regards to your specific needs, even though this topic is just generalized. But don't please make an application due to what we've discussed today. This is just a guidance, and also to let you know that there is always a way for you to regularize your stay. And this is one of the ways for you to regularize your stay. So, this is just to encourage you and also educate you, and, give you an insight of what is expected for you to put in your application. So please, 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 when you finish watching this program, contact Lawyer Eunice. You leave her details at the end of the show. Contact her, and Lawyer Eunice will have a personal discussion with you through that discussion, she'll be able to know how best to help you. Thank you for your understanding. So, Lawyer Eunice, any updates for this week?
Yes, so we have should I say, a collection of updates. So I'm just going to be brief as much as possible and let our viewers know what has gone on through this month. Um, First of all, I think that most of us know the decision of the Akitsenya case. So that
Yes,
came out in
yes.
January.
It's been dragging
Um,
on for a long time, isn't it?
yes, it has been. And so as soon as the decision came out, people were interested to know if they could apply and what it would entail, and if they were under the 2.5 year route to settlement, whether this would apply to them and the rest of it. So I think the Home Office had to take time to also bring out their own guidance because before the case went on to the Court of Appeal, they did come about with a consent agreement to say that if the Court of Appeal were to grant judgment or the appeal in favor of Miss Akisenya, then
Yeah.
they would give other people a 6 week period in which they could also put in their applications. And so, lo and behold, they also brought about their guidance this month
Oh,
to make people aware of where they stand in terms of the Court of Appeal judgment, and also to also make sure that people knew whether or not they would be granted leave under Appendix EU based on the Akisenya case. So the long
okay.
and short of it is that the Home Office has brought about their guidance, and they're still standing strong on their decision to make all those who have been granted leave to remain under Appendix FM. So if you have 2.5 years leave to remain, then you are a person who has leave under the rules, and therefore you will be ineligible to apply under
Right.
Appendix EU as a Zambrano right holder. But
Oh,
we are not saying that that is the law, because that is only a guidance for them to be able to make their decisions very clearly. Somebody who has a Zambrano right to reside under our previous immigration, I mean EEA regulation 2016, is
yeah.
a person who can show that they're a primary carer of a British citizen. They can show that the British citizen lives here in the UK, and
Okay.
also show that if they were refused and had to leave the UK, that would also mean that the British citizen will have to leave the UK with them. And then if they
Right.
had other children that were not British, those were their dependents. And so as long as their dependents were under the age of 18 and did not have any leave to remain whatsoever, they too would also be given a derivative right
Right.
under the regulations, because their parent was a derivative right holder. So
Right.
um, usually that would be the premise, because the regulations came about as a result of the Zambrano case, which was a case decided under the European Court of Justice. So that was our precedent, and that was what formed the regulations 2016 when most people made applications under the Zambrano. So, of course, the government has said they are going to exempt people who have leave to remain or
Mhm.
leave to enter from applying under the Zambrano route. That is unfortunately not the law when it comes to Regulation 16, because it
Okay.
very clearly states under Appendix EU that as long as the person satisfies Regulation 16, um, they also have a right to reside in the UK as a Zambrano primary carer. The only clause which exempts them is the fact that they may have leave to enter or remain under the rules, which is not so under our previous regulation
Oh,
16
okay.
20, and yeah, 2016. So Those that have leave to remain. So I think that's what people want to know. If I have 2.5 years, can I apply under the Zambrano route? Because
Mm-hmm.
the government has given a 6-week period which ends on the 25th of July.
Yes.
So from now up to the 25th of July, if you're asking yourself, do I want to make this decision to apply under the derivative rights? You should first of all ask yourself, am I a primary carer?
Yeah.
If you're a primary carer, that will be a tick. Then you ask yourself, is the British child here in the UK? That's a tick. Then you ask yourself, will this child have to leave the UK with me if I was refused?
Mm.
So, if for instance, I am the primary carer of this child, and then it happens that the child's father doesn't take care of this child, but the child's father lives here in the UK,
Mm.
because that child's father is also here in the UK, they can easily say that, well, if you are asked to leave the UK, the child would
The
not
child
have to
can go to
leave
the exactly.
because their father also resides here in the UK.
Mm.
So, unfortunately, you may see yourself as a primary carer, but under the rules, because the child has another parent here in the UK or guardian here in the UK, then that would also mean that that child could remain in the UK because there is another parent or another legal guardian that can care for this child if you were asked to leave the UK. And
Okay.
that is not so helpful. And of course, if you are thinking about making this application and you know very clearly that there is another primary carer, another parent, another legal guardian who can
Mhm.
care for this child, please, I think that it will be best to remain on the immigration rules. So under Appendix FM, you have the right to make the application as a parent who has sole responsibility or who has direct access or who I would say would normally live with the child. So if you are a step parent or a parent with sole responsibility or a parent with direct access, please, please, please remain on your 2.5 year leave
Okay.
unless you are able to say without a shadow of doubt you can meet the requirements under regulation 16. Then you can go ahead and put in the application under appendix 2, which is under the EU 11 of appendix EU, to be
Okay.
able to then regularize your stay under the Zambrano
Oh,
um, rules, or shall I say, the Zambrano right to reside. So that's for those who are looking to make applications under Appendix EU of our uh, 2019 amendments to the immigration rules. Then
okay.
we,
Well, Eunice, I'm. You see, talking about Zambrano, I
mhm,
think the question I wanted to ask was if both parents
mm,
are having regularized their stay
mm.
and they have a British child, can both of them be Zambrano parents?
Yes. So if for one reason or the other, you as a parent has a child and then you're living together with your husband or your wife, and this British child became British as a result of having lived here for a period of 10 years.
Yes.
So a child who was born in the UK and has lived here for the first 10 years of their life can register to be British. So if your child registered to be British at the age of 10
Mhm.
and both parents are now seeking to rely on this child as their primary carer. So it doesn't just have to be one parent, it can be both parents
Right.
who can say that they are primary carers of this
Mm.
British child. And therefore, because they are primary carers of this British child, they are deriving their right to reside here in the UK
Mm.
based on this child. And
Mm.
so, yes, if you are saying that you are not a sole primary carer and you are a joint primary carer, as long as you are able to say that you are the ones who care for this child, and there's no other primary carer or other person who can look after this child if you were removed, then of course this will also be applicable to you.
Yes.
And all categories, unless you already have a derivative right to reside. So I'm not talking to those who already have
Mm.
a derivative right to reside. So
The
these are
reason why I said that was,
Yeah.
I think a lot of people are of the notion that if it's only the sole parent, it's easier than both
both.
parents.
Okay.
Exactly. So people are not even sure that it's possible if both parents,
Parents.
because it's people are of the notion that if it's just
Yeah.
a sole parent, it's straightforward, and the success rate is higher, and probably there might be when it's both parents, it's
Yeah.
a bit complicated. That was why I asked that question. So there is
Okay.
hope, isn't it?
Yes, and I think because under our immigration rules, it's not so clear whether people can make the application as joint parents, because
Exactly.
under the immigration rules, it states that either you have sole responsibility or you have direct access, or you're a step parent who has genuine and subsistent relationship with this child. So under the immigration rules, it is not clear that you can make an application as joint parents. But with Zambrano, you can make the application either solely or jointly. And I think that's the beauty about Zambrano, because it just classifies a primary carer as somebody who is either related to this child as a parent, or somebody who's a legal guardian, or has been given some form of court order to be able to look after this child. And so it can include both parents, it can include anybody who has a court order, or a relative who has been given the right to look after this child. So that is the beauty about Zambrano. So you can make this application as a primary carer of a British child, and you are stating that without you being in the UK, if your application were to be refused, that would mean this child will also have to live with you. So it applies to a collection or a group of people. So
So,
yes,
yes, let's quickly go to, because if you don't take care, even talking
yeah.
about Zambrano has taken 22 minutes of our time. If you don't take care, we are going to be here for 2-3 hours.
Hours,
So
I
let's
know.
move
Yes,
to the next
the
update
next
and
update.
go to
So
what today's topic is.
yes, so in terms of those who are making applications for family members who are outside of the UK. So if, for instance, you are making an application for a spouse, you're making an application for a child who is under the age of 18, you are making an application for an adult dependent relative. As long as it's a human rights application, the Home Office has now given a guidance as to the fact that you can apply for fee waiver. So if, for instance, you as a family member in the UK want to make an application for another family member to join you outside of the UK, and for instance, you have leave to remain as a parent here, you want to go and bring your other child to come and join you here in the UK, you can apply for a fee waiver for that application for your child to join you. And once you have been granted a fee waiver, they will provide you with a code which you would use when making the actual application for your child to join you. It could be a spousal application, but remember, with the spousal application, the requirements are that you also have to meet a financial requirement, unless you are also somebody who is exempt from meeting the financial requirements. So usually people with some form of disability who are receiving some form of disability payment or allowance will be exempt people, and so those people as well can make an application for fee waiver for their spouses to join them here in the UK, or you may be making an application for an adult dependent relative. So all of these categories of people can now apply for fee waiver as long as it's a human rights application, and then they will be assessed as to whether they should be granted fee waiver before they make the actual application. So this is good news for those people who want to make entry clearance applications for those outside of the UK. Yeah, so it's fantastic news for them as well, because last month we were talking about British national children who can also make fee waiver applications as well. So this is also a good addition to the fee waiver applications that the government has agreed to allow people to be able to make. And then thirdly, I'll mention the fact that when it comes to the removal of people from the UK because they have made asylum claims, a lot of people have seen in the news that there were flights that were booked to be taking people to Rwanda, and fortunately, there were good lawyers at hand to apply for injunctions, which were able to stop those flights from leaving the UK. As I have said before, when it comes to making asylum claims, the UK has an obligation under the Refugee Convention. So it is a signatory to the United Nations Refugee Convention, and there are certain obligations that it has to abide by as one of the signatories. And so if for one reason or the other, somebody makes an asylum claim, and you, as a country who is a safe country, assess that person and you think that their claim is founded. So, what I mean by founded means that that person's claim that their life is at risk, or their beliefs, or their political views are at risk, has got some truth to it. So what they're saying is that if that claim is seen to be true or is seen to be well founded, then it means that that person cannot go back to that country where they are from, and they have to remain in the safe country where they have made their application for asylum. And so if they have come into a safe country, they can't then be removed to another safe country just because you have an agreement with another safe country, because there are procedures in place in terms of being a signatory to the UN Convention. Unless you are saying as a government that that person's claim is inadmissible because maybe they went through a safe country before coming to you, and maybe they put in a previous asylum claim. So maybe when they were coming, they stopped by at France before coming to the UK. They put in a claim in France, but they didn't have good living conditions, and they decided to take their chances and come to the UK. So if for one reason or the other it is found that the claim was put in France before they came here, then obviously they can go ahead and say you would have to return to France for them to assess your claim, because you did enter a safe country before coming here to the UK. So obviously they can't then bypass all these procedures in place to then remove people as they would like into another safe country. I know that most of these rules will come into effect from the 28th of this month, so which is next week, because a lot of people have been talking about the British Nationality and Borders Act, and a lot of things are in place in terms of not just the government's will to remove people and send them back to Rwanda, but there are things to do with British deprivation and tightening the rules in terms of immigration and the rest of it. So there are quite a few things that people need to look out for once the act starts to come into force. And so I think as and when those sections come into force, we will let the viewers know, and of course know how best to deal with those scenarios as well. So that's something that we can also look forward to. And then lastly but not least, I'll just briefly talk about the fact that when it comes to our applications as EU nationals and family members of EU nationals, please and very please, if you know you did enter the UK before 31st December 2020, then you can, of course, make an application under the EU settlement scheme. So if you are an EU national or a family member of an EU national and you came to reside in the UK before 31st December 2020, you can still make the application under the EU settlement scheme. But if for any reason you were not living here as an EU national, so if you don't have an EU national family member, or you yourself are not an EU national who came to reside here before 31st December 2020, unfortunately, you will not be able to make the application under the EU settlement scheme, because they have realized that a lot of people who have come after that date are making those applications under the EU settlement scheme. So they need proof to show that they were here as EU nationals or family members of EU nationals before the 31st of December 2020, in order that they don't send you back, for instance, when you travel. Because if they do realize that you did not have any status here in the UK, they are very likely to send you back to your country of origin, because you would have to have evidence that you are just coming for a visit and returning. So, if for any reason there is any way that you have not been able to apply to the EU settlement scheme, please do so as soon as possible, as the deadline was on the 30th of June 2021. So even if you're an EU national living in the UK, if you haven't done the application, please do so, as you can also be stopped at the ports or airports if you haven't been able to apply to the EU settlement scheme. So that's in terms of our updates. I'll leave it here, and then we can continue with our main topic for the day.
Yes. For those of you who are wondering what we are talking about, we haven't even delved into what the topic is for today. Lawyer Eunice was taking us through the updates for the week, and she spoke about the Zambrano applications, and today's topic is, how do I apply for immigration status in the UK based on one's private life. And as I said, if you have any questions, please feel free to send us those questions. If you prefer to call me live in the studio, of course you can do so on 0744 8619 711. The number again, 0744 8619 711. I would love to hear from you. I'll also, ask you to please share so that other people can also benefit from this educative program. Right, Lawyer Eunice.
Hi.
Good. So, regarding today's topic, who is really eligible to apply for leave under the appendix private life of, the immigration rules?
Okay, so very quickly, I'll just want to give a bit of a background. So prior to appendix private life coming into force from the 20th of June 2022, which is this month, there was the private life route under paragraph 276 ADE of our immigration rules. So most people would know under paragraph 276 ADE that we had the private life route applications, which most people would be able to make their applications. But as the immigration rules have changed, they decided to now create a different appendix to the immigration rules, which would provide those who have private life here in the UK a different, should I say, route to be able to make these applications. So when we talk about those that can make their applications under this new route, it includes people who it's not very different to what we had under paragraph 276 ADE. So it's very similar. It includes children who are under the age of 18 who have lived here continuously for a period of 7 years. It also includes young adults who are between the ages of 18 and are under the age of 25 who can show that they have lived here half of their life. So if I am 18 now and I came to the UK when I was 8 years old, that means that I have lived here an additional 9 years or 9.5 years. And so that is more than half of my life. And so that is that category of people. Or you're saying that you have lived in the UK for at least less than 20 years. So you're somebody who is above the age of 18. You've lived in the UK more than half of your life, but not necessarily 20 years. There is that group of people who can make an application. And then there are those that are 18 and above who have lived in the UK for at least 20 years, who are saying that they would also want to put in an application for either leave to remain in the UK under our appendix private life. And so private life has to do with the fact that you are telling the government that as somebody who has lived here in this country, formed deep social and cultural ties, you believe that the UK is your permanent home, and you have exercised that right to private life. So all people who have been part of our, should I say, government, or people who have been part of this uh, country's immigration, should I say, immigration rules and the things that have come into force would know that most of it is a result of the EU treaties, is a result of the EU laws, and even our human rights is a result of the fact that we were part of the EU. So all of this comes from the fact that there are human rights that were in place, and this also includes the fact that we also have a right to private life and to family life under Article 8 of our European Convention of Human Rights. So all of this is a result of the fact that we were part of the EU, and there were certain laws and treaties that made it possible that other people could also rely on these rights to be able to even regularize their stay here in the UK. So a lot of our rights as we know it is a result of the fact that we had those laws under the EU, which have now come into effect within our UK law as well. So, yes, when we talk about those people who are eligible, there are four categories of people who are eligible. And as I've said it, the children who are, should I say, under 18, who've lived here continuously for 7 years, those that are also 18 and above, who are under the age of 24, who have lived here at least half of their life, and then those that are 18 and above and have shown that they've lived here for less than 20 years, but there are serious obstacles which will stop them from going back to their country of origin. And then there are those that are above 18 and have shown that as much as possible, because they have lived here for a continuous period of 20 years, they too would want to put in an application to remain here in the UK.
So, Eunice, when you say one is lived there continuously for 7 years,
Yeah.
the word is continuously.
Yes.
Sometimes people don't really um, get it very clear what continuously means. Someone
Mm,
might say that, oh, when I had my child,
mm,
due to childcare issues, I had
yeah.
to take the child back home for my mom to look after the child. And when
Mm,
the child was 7 years, decided to bring the child back.
mm,
Someone might also say the child, lived with a family member for up to 6 months and
yes.
brought the child back. So when you say continuously, even though I understand that when it comes to immigration,
Yeah.
it's slightly different from when you go to the dictionary for
Yes.
a meaning of a certain word. So when you say continuously, in immigration terms, what does it mean? Does it mean not traveling at all to any other country, or not staying more than a certain number of uh, period of time? Can you please explain, because this is
Yeah.
something that gets people confused.
Yes. So it's good that the immigration rules also defines what this is as well. So under 276B, you have what it means to continuously reside.
Yeah.
So if you look at the definition of continuously reside, it also means that you can show that you have been resident here in the UK and have not been absent for a period of 6 months or more in a given 12-month period. So if, for instance, I say have lived here continuously um, in the UK, and I go to the definition of what continuously reside means under our immigration rules, I should be able to show that I was residing here and I wasn't absent for a period of at least 6 months or more within a 12-month period. So yes. Um, what would show that I was living here continuously? It could be the fact that the child is in school. It could be the fact that the child is over 18 and is working. If the child has a passport, you can show that this child hasn't traveled since they entered. If you're saying that this child has lived here, there will be some form of evidence to show that this child has lived here for that continuous period. I mean, showing absence is very is very easy, but
Yeah.
showing that you have resided, not so easy, because they
Mm.
want to see that you have proof of residing here for every 6 month period. So you should be able to provide them with that evidence as much as possible so that they know that you have lived here continuously for that period of time. So it's good that you asked that question, because I know um, like you said, the definition under your dictionary may be different from the definition that we have under the immigration rules. So if a
Okay.
parent decides to take that child away
Mhm.
and they bring them back when they're age 7, unfortunately, they will not be able to account for the years that they were not in the UK.
Okay.
And so
Okay.
if you cannot account for it,
Mm.
that's when there will be
All
issues.
right. Laura Eunice, we've got a caller on the line.
Okay.
Let me put him through, and he'll be able to ask his question. Hello, caller. You're welcome to the program. What's your name and where are you calling from?
Yes, my name is Kevin. I'm calling from Birmingham.
Wow. All right. Your question to Laura Eunice.
Yeah, my question is, I'm having a pre-status status, and I'm asking a lawyer, can I invite my parents for holidays without my partner assisting me
Okay. Laura
in
Eunice, did
terms
you
of
get the
documents?
question?
So I'm not sure what the question is. Can he go on holiday
No,
without?
invite his parents.
Oh,
In
okay.
fully invite his parents without his partner assisting him in terms of documents.
Okay, so if it's a visit application, obviously they would just need one person who is able to say that they would, for instance, accommodate them. Unless he's saying that he wants to financially maintain them as well when they come. So it depends what the household income is and whether his income is sufficient to sustain his parents if they were to depend on him financially.
Is there a
So
threshold for the financial support?
well, there isn't a threshold, but I would usually say that if you are making an application for a visit visa and you are the person accommodating that person, if you are also going to be the one providing for the financial support of that person, then the income support rate is a good basis to look at whether you'll be able to maintain that person. So, income support rate, they usually give it to parents with children who are not able to work. And so, for instance, maybe I might not be in a full-time job, or I might have a part-time job, and the income support that I would be receiving will be about £74.10 for me as a single parent. And then if I had children, it would be like £66 80 for the child.
Let me
But
ask
in
you,
his
Paula.
case,
Hello.
Hello.
Yes, you heard what Laura Eunice was saying. So, are you, do you have any dependents like children, or you single-handedly want to invite your parents over?
I have children, but they don't live with me. I live by myself.
You live by yourself, okay?
Yeah, and I'm full time.
Full time, yeah.
Yeah.
So, Laura Eunice, you heard?
okay.
Yeah.
Yes. So he lives alone. He wants to bring his parents over. He's
Yeah.
got a good income. So hopefully, if they look at his balance, they know that this is somebody who has some leftover money who will be able to also accommodate and financially support his parents when they come. So there is no specific amounts in terms of visit applications, but they want to be able to see that you have more than enough to support them when they come. So yes.
So what is more than enough, Laura Eunice, if I should ask?
So usually I would say to myself, how much does it take to look after me? If I say I need to be able to look after myself, how much food would I need? How much would I need to be able to look after
so you have to do the breakdown.
Yes. If I spend £200 on me in every given week, then that means that I should be able to have that amount in multiplication for every month. Yes.
Okay. Yeah. All right. Has she answered your question, caller?
Yes, but I wanted to know the pre-settle I have. Can I invite them?
So as long as you have valid leave to remain in the UK, you can invite whosoever you wish.
So you can invite them,
to the UK.
Okay.
All right.
Okay, because someone told me I can't because I'm having a pre-settle until I get settled.
No, that's not true.
That's not true.
With visit applications, anybody who has valid leave to remain in the UK can invite a person.
Yeah. So what I would advise you is, at the end of the program, Laura Eunice will leave her details. Please get in touch with her, because at this stage you can't afford to make any mistakes, since you are getting different, advice from people. So I will advise you, at the end of the program, Laura Eunice will leave her details. Please get in touch with her, so that she'll be able to guide you to, make the right decision and put in that application. All right?
Okay, thank you very much.
Okay, good luck. Take care. Bye. Right. Laura Eunice, so the next we spoke about, you were talking about the eligibility. Now, can we move to the requirements to apply based on the private life?
Okay. So as I was saying, when it comes to these categories of people who can make an application, you also have to look at what the immigration rules state about who and whether they will be eligible to make these applications. when you come to the immigration rules, there was always going to be suitability requirements, which would show whether this person can even make the application in the first instance. So somebody who is liable for a deportation order or who has been given an exclusion order will usually be somebody who would be unsuitable, basically, to make this application.
Okay.
And then you have things like people who may have, in one way or the other, breached immigration rules or didn't attend an interview when they were supposed to, or have NHS debts, or for one reason or the other, having abided by some immigration conditions, for instance, attending a reporting session where you have to continuously go and report. So there are things like that that come under whether a person is supposed to meet that suitability requirement, or somebody who, for one reason or the other, has misrepresented information to the Home Office at any given time. And there are categories of people who may, for one reason or the other, may have given different information to the Home Office in terms of a previous application that was made to come into the UK or whilst they were in the UK. So there are all these categories of people which the Home Office will look to assess whether they should still be given the eligibility to apply under the immigration rules. And for most of these cases, they may be refused, but if they are able to meet the eligibility requirements, then it may be that the discretion of the caseworker is exercised and they will not be refused in terms of an
Laura,
application.
just hold on for me 1 minute because
Okay.
I've got a caller on the line.
Okay.
So after the caller, then we probably can continue with the discussion.
Yeah.
Hello, caller. Your name and where are you calling from?
Hello, good afternoon. My name is Nana.
Okay.
I'm calling from Elisha.
Okay.
I just want to find out if I've made the Zambrano application. I've made the Zambrano application, but can I sue them if they say no to it?
So you want to find out if they can refuse your application?
Can refuse your application,
So
yeah.
in case they refuse, what should I do?
Okay, that's a very good question.
Okay. So first of all, I want to ask, how is
I think she's
your
gone.
Oh, okay, she's gone. Okay, so let's generalize it then, because there wasn't much information in what she said. So in terms of you making an application under the Appendix EU as a Zambrano primary carer, if you are saying that you've lived here continuously for a 5-year period and you have also looked after this British child for that period of time, you remember at the beginning I was giving those who are eligible to apply. So if you're a primary carer, this child who is British also lives in the UK, and if your application were to be refused, it would mean that the British child will also have to leave the UK with you. So if you are saying that as a primary carer, this British child has depended on you for everything that they need, and the application is refused, you have to go back to see whether the requirements were met. If that British child that you're looking after has another parent here in the UK, and that parent can also look after this child, they are likely to say, well, we are refusing the application because if you were to leave the UK, the British child will have another parent or another legal guardian or another relative who can look after this child.
Laura Eunice, the lady is on the line now. She's called back.
Oh, okay.
Yeah.
Okay.
So ask her the question you wanted to ask her. Nana.
Okay.
Yes, the lawyer would like to ask you a question.
So I was trying to find out, on what basis did your child become British?
So administrative since 10 years. So she is now almost 19. I have one who is almost 17, who is almost 18. And then I have one who is almost 15, going to 16.
Okay. So from what you're telling me, it means that when the children reach 10, that's when you made the registration applications for them. So that's fine. In terms of meeting the requirements, as long as you're able to meet the requirements, if your application is refused and you are taking your case to court, so if you lodge an appeal and you say, well, I meet all the requirements, I don't know why my application was refused, that's how you are able to then give the court all of the evidence to show that you meet the requirements under Regulation 16. And you know, the best thing about taking a case to court is that they follow precedent. So they look at cases that have gone on before them that gave them authority, and they are also able to follow on from those cases and grant it to you. So the good thing about taking your case on appeal is that the courts will follow the precedents that have been set, and they will grant it to you regardless of whether the Home Office would want to give it to you or not. So if you are refused, definitely appeal because you meet the requirements, and then the courts will follow the precedents that have been set, and they would grant you indefinite leave to remain if you are able to show that you have looked after this British child for a continuous period of 5 years. So yes, you can definitely be rest assured that even if you were refused, you would appeal and the courts will follow the precedents that have been set, especially in the case of Akisenya, and grant it to you. Yeah.
So, Nana,
Yes, darling.
are you happy with the response? I think it's a win-win for you, you know.
Yes.
Okay.
Yes, because the 2,000 that I have to pay at the end of my school now, it's very, very difficult for me.
Okay. So you have to take your time and mobilize yourself.
Okay.
Yes.
Okay.
All right. But if you probably, what our advice is, maybe Lawyer Eunice will be able to advise you on how you can get support to sort this thing out. Maybe if there's any way an application can be put in for a fee waiver. I don't know.
Okay.
So when you contact Lawyer Eunice, she'll leave her details at the end of the program. When you contact her, she'll be able to advise you further. But
So I want like to tell me if he's a solicitor, but I please.
My darling,
Yes,
this program is brought to you by one of the best law firm in this country, right?
Okay.
The platform is very credible. You can even go on their website and check their reviews. You can go on the Law Society platform and check for their details. You know what I'm talking about.
Yes.
All right?
I know, but I just want to know that if it's a solicitor, because I know a solicitor and I also know of a barrister.
No problem.
If it's a barrister, that is all that I want.
That is no problem. Be rest assured. I'm telling you, Lawyer Eunice is a solicitor and she works with a team of very good solicitors. That was why I asked you to also do your own due diligence by going to the Law Society platform to check the details of the company and the solicitors that work in that organization, so that you be rest assured it's not what I'm saying, but you have also looked out for it and you are now satisfied with what the reviews and information on that platform. So honestly speaking, this platform is a very credible platform. BWF solicitors, I can testify.
Okay.
All right. So please be rest assured. I know a lot of people have had bad experiences with other solicitors, but trust me, I'm not, fronting this program just for people to be, what do you say? People to be taken for granted. Okay. So as I said, contact Lawyer Eunice. Lawyer Eunice is a very good solicitor. She's got a very good track record, and her company as well. All right?
Okay, thank you very much.
You're welcome. Have a lovely day.
You too. Bye.
Right. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors, your Saturday immigration education show. People are calling in, asking questions. This is what we want. We want it to be collective. We don't want it to be just a two-way kind of program. So I'm very excited. People are engaging. People are calling in, asking their questions. We need more people to call in, send in their questions as well. Today's topic is how to apply for immigration status in the UK based on your private life. And with me has been Lawyer Eunice Achampong. She's a top-notch solicitor and also a partner at BWF Solicitors. And I am also your host, Vicky Newton. Lawyer Eunice, were you done with talking about the requirements?
Yes, so I was just saying that, of course, when it comes to the suitability requirements, once you also meet the eligibility requirements, which state that you should be able to show that you've lived here continuously for either 7 years, or you have lived here for at least half of your life because you are between the ages of 18 to 24, or you are somebody who is above the age of 18 who has lived in the UK for at least 20 years, or you are somebody who has lived here for less than 20 years, but you have reached the age of 18 or above. And so if you are able to say that because you as a person have the rights to private life here in the UK, they should consider that right to private life because you have formed those cultural ties, you formed those social ties, and you see the UK very much as your home. And therefore, because of that right that you have established here in the UK, you do meet the eligibility requirements. And if for any reason or the other there are any suitability requirements which you may fall foul of, they should use their discretion if it is not a mandatory discretion, as in you are not somebody who has a deportation order or somebody who has an exclusion order, then they will go ahead and use their discretion when looking at your application or assessing your evidence to meeting those eligibility requirements. So yes, that is that in terms of our immigration rules appendix PL.
Right. So when is a valid application not required?
So if, for instance, somebody were making this application, they would want to make sure that they are making the application online, that they are paying the correct application fee, that they are putting in their valid passport details, and that they are also going to provide their biometrics after they've submitted their application. There will be instances where you would not need to provide a valid application form with fees and your passport and your biometrics. And those are people who, for instance, have put in an asylum claim. The claim has not been decided for years, and I hear that there are over 20,000 asylum claims since this conservative government came into force. So there are quite a lot of claims that have been put to the shelf. So there's a backlog. And so if it happens that you are able to meet one of these requirements and you previously put in an asylum claim, it may be that you wouldn't have to make a valid application. All you do is to make further representations to the Home Office to consider your private life under the immigration rules. Or maybe for one reason or the other, you are saying that you're a person who has previously made a protection claim and you're somebody who has been detained, and as part of your efforts to be given bail, you are making further representations to the Home Office to make sure that they will also consider the fact that you have formed private life here in the UK, and because um, they should consider that Article 8 right to private life, you are telling them maybe you don't have family members, but you do meet the requirements under private life, and therefore they should look at that aspect and grant you leave to remain in the UK. So these are some categories of people who may not necessarily um, need to make a valid application like the normal everyday people who
Okay.
are in the UK who want to make an application to remain here.
Okay. Right. So I've got Nana on, on Facebook. Hi, Nana. Thank you so much. He sent in a question. Good afternoon, Lawyer Eunice and Vicky. Keep up the good work. I'm really enjoying the show. I've heard from other people that children can apply for indefinite leave when they are 7 years or old. 7 years old, or are more than 18 but have lived here more than half their life. My wife and I do not have any immigration status in the UK. We have two children who are 7 and 9 years old. We would like to find out if we can apply for our children to get their indefinite leave. Can we also apply for our leave based on them, or do we have to wait till they get their leave?
So it's two questions in one. He wants to know, first of all, whether the child can apply for indefinite leave and whether they can also depend on the child or the children when they are making the application.
Yes.
It's interesting that he says that one of the children is 9.
Yes.
It's obvious that if the child who is 7 has lived here in the UK for a continuous period of 7 years, then they are more likely to make the application for indefinite leave to remain. And with that, as long as they are able to show with their birth certificate that they were born here in the UK, school letters to show that, well, they've attended school and nursery here, or they have their health red record book, they can show that, yes, they've lived here for that continuous 7-year period, and then put in an application under the private life route, and then obviously make submissions that they're making the application for indefinite leave to remain because of the fact that they've lived here for a continuous period of 7 years. When it comes to the child who is 9 years old, maybe they're left for a few months till they turn 10. So I would say that they should wait till the child is 10 and then make the registration application for that particular child. Because when you make the application for indefinite leave to remain, you're going to be paying fees. And then when the child turns 10, you're going to be paying another set of fees for the registration. So, in order that you are not breaking your bank account, just wait till the child turns 10 and then do the registration for that child to be British.
Right.
And in terms of whether they are able to make the application to depend on that child, yes, you can. So, whilst making the application for that child who is 7 years old, you too can put in your application as parents of that child. So if you are saying that this child has now turned 7, an application for indefinite leave has now been made for this child, and therefore you would want to make an application for leave to remain under Appendix FM so that they recognize the fact that you have a genuine and subsistent parental relationship with this child, then you can go ahead and put in the application. There's no need for you to wait for a decision to be made for the child before you put in your application. So the two can be done hand in hand. Yeah.
Okay. All right. Brilliant. Right. Another question. This person doesn't want their name mentioned, So I'll respect that. She says, I applied for leave to remain based on living in the UK for more than half of my life. I first applied when I was 21 years old and was granted 2.5 years. I'm now 24 years and applying for the next 2.5 years. As you said, the rules have now changed. So does it mean I will automatically be granted indefinite leave to remain after I've lived here lawfully for 5 years? Eunice.
So, when it comes to those that have lived here for more than half of their life, the immigration rules is quite clear that if you are able to show that you have lived here legally for a period of 5 years and you are still between the ages of 18 to 24 years old, or should I say under 25, then you can put in an application for them to consider that you have lived here for that lawful period of time and you are making an application for indefinite leave to remain. However, this person has lived in the UK for 2.5 years and they are now making an application for the next 2.5 years. She is currently 24 years old.
Yes.
By the time she completes her 5-year period, she'll be about 27 years of age. So she will not come in that category of uh, young adults between the ages of 18 to 24 years old. So if that is the case, then that would mean that she will not be able to apply for indefinite leave to remain
Okay.
once she reaches the age of 25. So once she's reached that age, she will have to continue on the route that she was on for a 10-year period. So what I would usually say is that because the rules are very clear as to the age group of people who are to apply under half their life, I think that it's important to realize that the section which clearly states that a person can make the application if they are more than 18 but have lived here less than 20 years will be applicable in her situation. So when she turns 27, she will have to apply for leave to remain, but she can make it under the category that she has lived here for less than 20 years and is now above the age of 18. She is showing that she has formed private life here in the UK, and because her ties are mainly here in the UK, she really hasn't got um, maybe social ties back in the country where she's from. Therefore, there will be obstacles to her going back to her country of origin, and therefore she needs to remain here in the UK to be able to continue to benefit from the fact that she has lived here lawfully for that period of time. So that takes that person off from the normal route they were on to this route where they have to show that they have lived here less than 20 years but are above the age of 18. So, unfortunately for her, she wouldn't be able to apply for indefinite leave to remain, but she can go on and apply for further leave to remain under the immigration rules.
Laura Eunice, we've got another caller on the line. Hello, caller. What's your name and where are you calling from?
Yeah, my name is Atakwe. I'm calling from Liverpool.
Hello, Atakwe. You're welcome. Can you please, give your questions, please? Eunice is here.
Yes, I want to find out if you are on 5-year route. You are a British, you're married to a British citizen, and you are on 5 years route, and you are now applying for your indefinite. Can you apply for British passport at the same time, or you have to apply for the indefinite and then wait for some time before applying for British passport? That is the first question I would like to ask.
Eunice, did you get the question?
So if somebody has come as a spouse and they're on the 5-year route to indefinite leave to remain, once they complete their 5-year route, they can make the application for indefinite leave to remain. So making that application for indefinite leave to remain, they should have indefinite leave to remain, because one of the requirements under our British Nationality Act is that they are able to show that they have no restrictions to their immigration status here in the UK. So they can't make that application at the same time as their British naturalization application. They have to first of all wait to get their decision that they've been granted indefinite leave to remain, and then apply for their naturalization. If they're married to a British spouse, they don't have to wait 1 year like those that are not married to British spouses. So if they get their indefinite leave to remain today, they can make their naturalization application today.
Okay.
Okay, the second question I want to find out, if someone is, on 5-year route and now she's very sick and cannot take the maybe the exams and very sick now, can they still apply for the indefinite based on sickness?
What exams are you talking about, please?
I think it's the life in the UK.
Oh, life in the UK. Okay.
And the English language.
You get the question?
Yes. So if, for instance, that person is very sick, when it comes to the immigration rules and whether they can exempt that person from taking the exams, usually the people that exempt are people who are between the ages of, let's say, 4 to 17. So if you're under the age of 18, or you are above the age of 65 and you are making this application for indefinite leave to remain, you will automatically be exempt from the life in the UK test and the English language test, unless you are able to show that you maybe have some form of mental disorder, or you are saying that because you are critically ill, the evidence shows that you will not be able to take these exams at all. So it is not, you will not be able to take these exams for this short period of time. It is, you will not be able to take these exams at all,
At all.
regardless. So if, for instance, this person is likely to get better in 2 years' time, in 1 year's time, then they will say no, she will have to take the exams. And so even if there's medical evidence to say that this person is critically ill and she can't take the exams at the moment, they will want to know, is this person likely to get better? How
Yes.
soon is the prognosis that she will get better in so and so time? If that is the case, then they will give that person further leave to remain, so another 2.5 years. If then she is able to take the exams, then she can apply for indefinite leave to remain. So it is not enough to say that the person is ill and can't take the exams. They want to know that the sickness is something that will prevent her from taking the exams at all. So I know a lot of people want to get ways around taking the exams, but unfortunately it's very difficult to say that they will give that person the right to be exempt from taking the exams.
Is
I
your
think
question answered, please?
the threshold is
Okay. All right then. Thank you for calling in. Take care. Bye. I think I had another call on the line. Let me
Okay.
check. I think he was holding on. Probably I might have lost him. Okay. Laura Eulis, yes, let's get
Yeah.
on with I think you were talking about the
the person who says that she's lived here for more than half of her life,
half of her
and
life. Yeah.
concluding to say that unfortunately, by the time her 5-year period has ended, she will be above the age of 25. So she wouldn't come into that category of those who are 18 and under the age of 25. So for that reason, she would now have to say that she has lived in the UK for less than 20 years. However, she is above the age of 18, and because there will be obstacles to her going back to her country of origin, she would then have to establish that because she's from private life here in the UK, unfortunately, she cannot go back to her country of origin, and therefore she should be granted further leave to remain here in the UK.
Eunice, I've got this. I told you I lost a caller. He's on the line, and he wants to speak our local dialect. He's more comfortable speaking in the Chi language. So,
Okay.
Pacho, Akwa Bana, Udini baby, I offer fee.
Well, in case my point.
Yo.
Madam, your problem, so in Busama anyway.
Okay.
Or EU family member now. Or when I said channel, and I will, so now I'm a Canadian females. Then I said, an election or ban or young hostile in James our Rian Pesego.
Okay.
And a partner young hostile in our Rian Pesego. And then I will prove a just or not Nabu Vienna and females, but Umari and new females and Tiano or Pesu Busaloya said, the chances say,
Eunice.
Okay, and see, Ban said, oh yeah, application based on the fact that we're retaining our rights. No, the EA regulations were very clear as to NIPA, what I said, what EU national or retaining the rights. Either said, what I said, NIPA, no, yeah, EU, we free mean see, retaining our rights. And I said, NIPA, no, yeah, EU, on a chrome habium in see, so we free a chrome ha. We are non-EA national no or retaining rights. And I said thirdly, Wawari EU national, Mawari no last stay at least 3 years. Now, so you should say mutina chrome ha at least ubetumi aka say mutina chrome ha for at least 1 year. And say our no and last stay for that 3-year period there, and they're very difficult say obetumi aye application to retain the rights under appendix EU. It is very important say obetumi actually say at least our no last stay for 3 years. Until say almost year our rejaya crampo na it should show say final divorce absolute and I say final divorce certificate no ever after 3 years of our no rather than before the 3 years. Otherwise, it means that ABS Akolana you're British and he will have to switch from the EU route to Akolana so to be able to then have his stay regularized in the UK. And see, maybe he needs further legal advice in terms of the routes no or no.
Pacho, what you say?
Okay, so in that case, it's not what's it be or in the banning of British, maybe a vessel which Ubeku
So it is likely says so when to me I'm retaining the rights now, then he will have no basis to be in the UK. Unless he's able to show that he is able to meet either one of the categories, like I've mentioned, so will be our what's now Chrome had 20 years, will be to me at shred there, and there, maybe I will be to me at switch to that route. And I said, well, Bano, what's now a Chrome have for at least 7 years into what's not have for at least 7 years. No, you are making the application to say, oh yeah, I call the primary care into Osha, and I said, Nebano, you're British, and then you are saying, say, because I call so you're British, no. Or your application to show say Akolano at least why you're British in say or your application to depend on him. But in this case, Akolano we did 3 into so Akolano you're British and binim say Akolano you're EA national. Into say mommy were indefinite, na Akolano so were indefinite, then the likelihood of the child being registered as British is very likely. Into maybe he should talk to Akolani Mami non-registered as British.
Me Pacho, they met me can say so bet me am down for no program no lawyer Eunice beja the details. And nanka wadan for na kwa lawyer Eunice na cheso ne na se na o ma hwe kwan befa so a bia se kwan bi wo ho a obetimi aboa na because program yi so na bia na bibia na ye betimi edi ho nkomo nti ono abetu no for wo me Pacho yo mate yo mate me da se wa frɛ why me da se bye bye yes Lawyer Eunice.
Yes,
there you
go. So yes, to help that lady, I will say that she also needs to seek legal advice once her 2.5 is coming to an end, so that she knows the best way forward in terms of applying for
Okay.
her further leave to remain. Yeah.
Okay. All right. Right. So my last question, hopefully, is from this lady. She said I shouldn't mention her name. Okay, that's fine. I have lived in the UK for over 20 years and gathered evidence to show that I was living in the UK over that period of time. Will I be granted indefinite leave to remain when I apply? Is it likely that my application can also be refused?
Okay, so when it comes to a person who has lived here continuously for that 20-year period, um, fortunately or unfortunately, you will be granted leave to remain, but you wouldn't come under the concession or the current immigration rules in terms of children and young adults. So
Okay.
those that can apply specifically for indefinite leave to remain are children and young adults. I know people who are saying, "Oh, but I've lived here for 20 years. I the immigration rules are saying this, so it means that I can also apply for indefinite leave to remain if I'm able to show I've lived here for 20 years."
Yes.
Um, People talk so much about amnesty, and maybe this is
Yes.
one of those things. Unfortunately, they haven't included that under our immigration rules. You can still make the application. You will be granted a period of at least 30 months. I
Mm.
mean, when it comes to the children and young adults, they have the choice of applying for indefinite leave when it comes to making payments. So, for instance, they make an online application, then they ask them, would you want a period of 60 months, for instance, in making that application for a 5-year roots application? Then they tell them, okay, you can pay this amount. Or if the 5-year period has come to an end, they can
Yeah.
make an application for indefinite leave to remain instead. But it is not so for those who have lived here for a 20-year period. So
Period.
unfortunately,
Okay.
if you have resided here in the UK for at least 20 years and you are making the application, you will be granted a period of at least 30 months. Whether your application is successful or unsuccessful will be determined by the evidence that you put forward. So
Mm.
if for one reason or the other your application is refused because maybe you are not able to show that you've lived here continuously for that 20-year period, which is
Mm.
continuously, um, we decided to look at what it means to reside here continuously, which means that you haven't been absent for at least 6 months within a 12-month period. Then that means that you will have to provide further evidence that you have lived in the UK for that 20-year period. And because it's a human rights application, definitely you will be given the right of appeal, and you will be able to appeal and show your evidence that you have lived here for that continuous period. Obviously, when it comes to appeals, I always say it's always better to seek proper legal advice rather
Exactly.
than doing it yourself, because it will include uh, terms that you may not be familiar with. And it is not just about showing evidence. Sometimes you need legal representation to be able to deal with an oral hearing, and putting the bundle together, and the rest of it that comes together with a normal oral hearing appeal. So please, 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 if you are in that situation, do seek proper legal advice and don't just put in an appeal on your own.
Right.
Yeah.
Lawyer Eunice, I've got two questions on Facebook. Um, one from Bell Yankee and one from Dellington Smile.
Okay.
Bell Yankee says, I currently have a pre-settled status, and I lived and have been married since 2019. I would like to know if I qualify for maintenance loan through student finance.
Okay, so he's now got pre-settled status, which is leave to remain since 2019. I know as part of the student finance residence requirement, you should be able to show that you've lived here lawfully for at least 3 years. So
Okay.
apart from the residence requirements, they have eligibility requirements.
Okay.
And so the eligibility requirements um do not only include your lawful residence, but they include things like you showing that you have either settled status or you are somebody who has been given humanitarian protection or
Right.
you have been granted your asylum status, or you are saying to them that maybe you're a family member of an EU national, you have been granted settled status, or you are saying to them that maybe your family member is British or settled, and therefore you are also making the application as a family member of a settled person,
Okay.
or you are showing that you are somebody who has lived there at least half of their lifetime or has lived there for a continuous period of 20 years. So all of these come under the eligibility requirements. And so if he's able to meet the residence requirements, he has to check whether he can also meet the other eligibility requirements before
Okay.
he will be
Okay.
granted full student finance. Yeah.
Okay. Right. Let me go to my. I keep on saying last question, but I mean this is really my last question. Good afternoon, everyone. I would like to ask, based on private life, if he's over 30 years and has lived for 3 years continually, can he apply for his stay in UK?
Hmm. It's a bit tricky because if he has stayed here for 30 years,
Mm-hmm.
and then he's lived here for 3 years continuously. Is it that he has had lawful residence for that 3 year period, or they went away and then they came back
Mm,
and they've lived here continuously for a 3 year period?
yeah.
Um, because I'm not exactly sure, I'm gonna generalize it. So
Okay.
in terms of that person having lived here for 30 years,
Mm,
if for instance they have 3 years lawful residence already and they have it based on another route because maybe they have a child or a spouse or whatever it is, and they've lived there for that 3 year period, I would say stay on whichever route you are still on,
okay.
because if you are going to make the application based on your private life because you have lived here for 20 years, you will
Mm,
be given further leave to remain, which is 2.5 years, and you
okay.
will have to complete a 10-year period before you can apply for indefinite leave to remain. So if he has been given lawful residence under a different route and therefore he has resided here for a 3 year period already, he should just continue on that route. And then once his 10 years is up, he can make the application for indefinite leave to remain. Yeah.
Okay. All right. Thank you so much, Laura Eunice. So let's quickly summarize what we've discussed so far in just a few words and also
Okay.
leave your details. I've got so many people asking for your details, where they can, get you your contact details for them to book an appointment to come and see you. Then I think we wrap up the show. We've gone over by 30 minutes, but it's all good.
Oh, thank
Yeah.
you so much. Thank you for your patience.
All right.
So I know Sandra Fraser has dutifully and very hospitably put our contact details down and our telephone numbers and address and opening time. So um, thank you so much, Sandra Fraser. And just to summarize, I know our immigration rules concerning our children and our young adults has changed for the better. And so if you find yourself under any of the categories that we mentioned today, either that you have lived here as a child under the age of 18 for a continuous period of 7 years, or you're a young adult between the ages of 18 and under 25 for a period of at least half of your life, and you have lawfully resided here for a 5 year period, or you are still making an application as a child or a young adult who is above the age of 18 and has lived here less than 20 years, or you an adult who has lived here for a continuous period of 20 years and you want to make this application based on the fact that you have established a private life here in the UK, you can go ahead, seek proper legal advice, and know which application best suits you. Before we end the program, I would like to say a big thank you to all of our viewers, those that have been watching us on Facebook and YouTube. We are very grateful for your support and the contributions that you have made towards the program. We are BWS Solicitors. We are situated in London. Our contact number is 0208 493 7340. So it's 0208 493 7340. Our opening hours are from Monday to Friday, 9:30 a.m. to 6 p.m. Greenwich Meridian time. And for those of you who want to call me after the program, my telephone number is 075 35 81 3910. So 075 35 81 3910.
Hey, Laura Eunice, I like the way you went Greenwich Meridian time. Wow. Ladies and gentlemen, on that note, we have come to the end of the show. I did really enjoy myself. I, at the same time, learned so much from what was discussed today. At least if someone approaches me, saying, Vicky, how do I apply, for my immigration status based on my, the private life? At least I can tell them there is hope and there's certain things that the Home Office expects you to, have in regards to requirements for you to be eligible. Then after saying that, I will direct them straight to BWF Solicitors for them to take the case on, for them to, put in the application for you. And I believe that you've also learned so much from today's discussion. If you shared, probably someone would have benefited from this program. If you observe the number of phone calls that we received, you know that a lot of people really need help. And I believe that through this program, people are going to, be able to sort out their immigration status. I'd like to say a big thank you to Lawyer Eunice and her team at BWF Solicitors for coming our way and, educating us and also giving us hope that there is a way for us to be legal in this country. Lawyer Eunice, thank you so much. And I also want to say so much, thank you so much to you for making this what it is today. Without you, we wouldn't have this show, even though we can still have the show, but you made this show a success. And I believe that you continue to support us. The sky is the limit, we say. So until then, we will meet again with another interesting topic. Take good care of yourselves and have a lovely weekend. Lioness?
Thank you so much.
As well, yes.
Thank you.
All right. Take care and God bless. Bye-bye.
Bye-bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.